Number 132. Counsel, do you like any rebuttal time?
I have 2 minutes, Your Honor.
How much?
2 minutes, please?
2. Okay, you're on. Go ahead.
Thank you, Your Honor. And may it please the Court, Jeffrey Kuiper for the people. Even if we imagine there was a mode of proceedings, or even if we imagine there was an error here, it wasn't a mode of proceedings error. This Court, in its ORAMA jurisprudence, has developed a very clear rule about what constitutes a mode of proceedings in the jury note context. And that rule has been, it's clearly stated in ORAMA. It's made even more clear.
Were these notes ever answered by the judge?
I beg your pardon?
Were the notes answered by the judge after the break?
No, there were outstanding.
Isn't that a break in the ORAMA protocols?
It may be a break in the ORAMA protocol, but this Court has made very clear that not every break in the ORAMA protocol.
But there are very limited instances where it's not a break. How does this fit into those few instances where we've said, all right, maybe they knew what the judge was going to say, whatever it was. How does this particular situation fit into that,
right,
those breaks, as you call them?
Right. The rule has been very clear that if the defense has notice of the exact contents of the note and the judge's intended response, any claim about error and how the judge responds to it.
So here we know what the response would have been to these notes?
Yes. Yes. The judge discusses this with counsel, indicates what's going to happen. Then before that does in fact happen, they get the note indicating that the jury has reached a verdict.
Here's the problem, as I perceived it and what the appellate division said. They said the jury may have resolved the factual issue regarding whether the eyewitness testified that she saw the defendant leave the scene without further instruction or assistance from the court. However, the request for a readback of the instruction on reasonable doubt, the determination of which is the crux of a jury's function, and for a readback of the instruction regarding the importance of single witness in a case versus multiple witnesses demonstrates confusion and doubt that exists in the minds of the jury with respect to crucial issues of law. And isn't that an interesting distinction that should be made, that they apparently resolved legal issues that they had questions about without further guidance from the lawyers or from the judge?
Right. I mean, the Fourth Department doesn't even take the position that the defense is taking. The majority of the Fourth Department didn't take the position that the defense, as I read their brief, is taking, which is that all of those are mode of proceedings errors, that the jury can't have resolved the factual question either. Now, I mean, I don't know that there's any – I can't fathom how you draw that distinction between questions that the jurors can't have resolved on their own versus questions they can. For one thing, we don't know what's prompting these questions. I mean,
well, that argues in favor of the defense, that we shouldn't parse it. We should say all of them have to be answered by the court.
I think it weighs in favor of having the same rule for all notes.
Okay.
I don't think that makes it a mode of proceedings error to
Would it have been an acceptable counsel, instead of the court answering each note, once the jury sent out the note saying it had arrived at a verdict, would it have been acceptable for the court to ask, do you need this other information that you asked for before you send out your latest note? Would that have been acceptable? Would that have been some form of answer?
It certainly would have been acceptable, and the defense could have asked for that. And that's – I mean, that was the situation in Loretta, which is a pre-Orama case. But there, this Court found it was error where the defense said, no, I want you to at least ask them, do you still need those previous notes?
But is this waivable by the defense? Is that what you're saying?
Yeah, I mean, it's certainly waivable unless it's a mode of proceedings error. And I mean, here, and that's why I think it's important.
Can the jury, are they competent to without the answers, to reach a verdict?
Well, I don't think – I mean, I guess I would want to step back from that a little bit and say there hasn't been any dispute here that the jury can withdraw a request. I mean, that happened.
We don't know if that happened really here. So, you see, if defense counsel had said, well, Your Honor, that's fine, they have a note, but I want to preserve my objection if you're not going to respond and give them the reading on this, then we wouldn't be here.
Well, I mean, I guess it depends.
But this way, if they don't preserve their objection, they get the verdict, and then they have in their pocket, if it's a mode of proceeding error, a new trial, which is the core of your argument. You either got to object and get your answer and get it on the record, so at least the judge can respond and correct the error. Or if not, then you can't hold it in your pocket and wait.
Absolutely. He wants it heads I win, tails you lose. And the mode of procedure, the reason for the preservation requirement is exactly that. You would have a record here.
Well, the mode of proceeding there, of course, would have to apply to the first prong as to what the note actually said, because then counsel wouldn't have any notice. They got to have notice to deal with this issue.
Absolutely.
And so that's essential. So the decision for us is the second part, really.
Right.
Don't they have to have full participation? Isn't this what the ORAMA protocols are all about?
Sure. But again, I want to draw that distinction
You're
between
saying
mode of
that they
proceedings
don't-
and error. Because, ORAMA gives us a very specific reason that the error in that case is a mode of proceedings error as opposed to just an error.
Because they're not getting full participation.
Right. Because defense
And did
can't
they get
object to something they don't know
Did they
about.
get full participation here?
But
Or you're saying
I'm
they
saying-
waived full participation?
I'm saying the defense had the opportunity, which is what ORAMA was
You're
concerned
saying
with.
they waived full participation.
I'm saying,
But ORAMA is about
saying
full
that-
participation. You can't waive that. That's the whole basis of it.
No, ORAMA says that the issue is that the defense attorney can't object to what he doesn't know about.
So you're saying he had notice.
Absolutely.
And
made a strategic choice. And that, I think, is the essence of it. This is the most purely strategic choice you could ever have.
So why doesn't People v. Laredo, though, control this case? Is it because it's a pre-ORAMA case?
No, because there's an objection. Certainly, if the defense attorney here said, I don't want you to take the verdict. I want you to ask them, do you still need those notes? But the defense has a good reason to not want to do that.
People versus Silva.
Yeah, People versus Silva, and the defense relies on it. People versus Silva involves a very different...
Isn't it the same case, basically?
No, not at all. Silva is decided, as I read Silva, on the fact that there was no notice, and that you can't infer notice from a silent record. So the question is, can the verdict, let's call it an implied withdrawal of the notes, can it subsequently cure a mode of proceedings error? That has nothing to do with this.
Is there? I don't remember exactly, but I thought in Silva there was no record of actually telling them what the court exhibit said. I thought that
Right.
There was no, and here we don't have that problem.
Right. Here it's clear.
What was the strategy? You say it's so clear that there was a strategic choice here. What was the defense strategy?
Yeah, if I think that the jury, which has been hung, has now resolved its problems in favor of me, I don't want you to send them back to get rehung. If I think this case has gone well for me, I put on my defendant. I had all my alibi witnesses. This case has gone well.
And if I don't say anything and it goes the other way, now I can claim it's a mode of proceedings error.
Right. If it's mode of proceedings error, then it's malpractice to say anything.
That's why it would be error, just like the judge said, or it may be error, but you got to preserve it if you want to save it for later. But then if you preserve it, the judge is going to correct the error immediately. So.
Right. And which I think, again, is the ORAMA rule works. It works well. It cures errors. It functions properly the way it is.
So you wouldn't know that today, given the cases we have today.
But you don't get these cases about, the judge promised to do this, and I wanted him to do this other. You don't get into a lot of that sort of parsing of things, because generally speaking, if the defense says, no, I think this note is asking for this, I want this, it gets worked out. It's a functional rule. And
Okay, Counselor, you got your rebuttal. Let's hear your adversary.
Thank you, Judge, and good afternoon, and may it please the Court. Nick Borton from Sullivan and Cromwell for the respondent, Terrence Mack. The holding of ORAMA is very clear, and its application here.
Did you know exactly what the note said?
The defense counsel knew exactly what the note said, but not the time that it was submitted. And that is clear. And
Where
that
does
goes.
ORAMA say you have to know the time that it was submitted?
ORAMA says that for notice to be adequate, for notice to be meaningful, the defense counsel must understand all of the specifics of the note, and this is the language that's important, so that he can understand the situation in the jury room.
Counsel, in this situation, didn't the judge indicate that they were going to take a dinner recess and that any notes that the jury sent out would be responded to or dealt with after dinner? So these notes came out during the dinner recess. And that wasn't all day, right? It was a specific amount of time, wasn't it? Like an hour, 2 hours, or something like that?
You're right, Judge Abdus-Salam, except for one important fact. He didn't say that to the jury. The jury had every note that day responded to either immediately, within a minute from the record, or in one case, within 20 minutes. He sent the jury away after instructing them there was no time limit on their deliberation.
You're arguing that counsel needed to know the time of the notes.
What's the impact?
Counsel needed to understand the time of the note to understand, as Arama says, the situation in the jury room.
Okay, but Judge Abdus-Salam knows, as Judge Abdus-Salam indicated, they knew that there was this period of time during the dinner break, so it had to be sometime during that time.
Right.
And they knew what the note said. They could have asked, when were these notes received?
But the case law says counsel doesn't have to ask. That meaningful notice requires that the court make counsel aware of all of the pertinent
Counsel
portions
can't
of
waive.
That's not
Counsel
substantive.
can't waive. Is that what it is?
Counsel cannot waive.
But
And this
the
is
timing is really not substantive. That's not part of the note. That the jury doesn't ask.
we think it was.
At 6:54 p.m., we want to know X, Y, or Z. That is part of the note itself, because most judges, I know I did when I was a trial judge, put the time on there.
In this case, the time was on the notice. It was never read into the record.
So
And
I'm
we know
really
from
unclear. What is it that the counsel did not know?
he didn't know the time the notes were issued. And you know why we
But he knows that it's, I see where Judge Abdus-Salam was asking you, that he knows that it's only during this break, it's less than a 2-hour period of time. He may not know that it was 5 minutes after the break started, 5 minutes before the break ended. Why is that
Because he
level of
thought it was
specificity necessary?
He thought it was 5 minutes before the verdict, and we know that's what he thought because that's what he said in his affidavit.
But actually, it was about an hour?
It was 94 minutes. It was an hour and a half.
Yeah, at a minimum.
At 8 o'clock on a Friday
Saying
night.
the defense counsel didn't realize that this might really spill over into a period of undue delay.
Correct. Now, that's notice. I do want to focus on the second prong, the second core responsibility of Arama, which also was fundamentally not complied with here. And that is that no response was ever given to the jury. In a sense, what the people want is they want to take two core responsibilities under Arama, which the case law very clear that there are two, and they want to turn them into
So
one.
what should the judge have done in this situation about responding? They say they have a verdict. What does the judge do?
The judge should have done exactly what Judge Abdus-Salam suggested, which was to bring the jury into the courtroom and say, at a minimum, the judge should have said, we understand you've reached a verdict. We know, however, that we have not had a chance to respond to 3 questions that you had, and get some sort of confirmation either by polling the jurors or by sending them back.
What if counsel didn't want him or the judge to do that? What if counsel wanted to do what he did, which is to essentially hear the verdict, and if it was in favor of his client, then no need to answer those questions? And
Counsel doesn't have that right under the law. CPL 310.30 is very clear. It puts an obligation on the court, not on counsel, or not on the defendant, to ensure that requests from the jury are answered.
Yeah, but what you're saying is that if defense counsel says, whatever you do, I don't want you to read those notes, and not going to do it. You think that's going to help the defendant? Well, I'm telling you, I'm going to do it, because I think it helps the people. I think defense lawyers have broad discretion here, and I'm not, I didn't see where this is a great strategy. But I don't know. If I thought it was leaning the right way, I might say, Judge, I don't want you to go into, reasonable doubt again.
But again, to avoid that kind of gamesmanship, a bright line rule is needed. And if the rule is jury questions always get answered unless they're explicitly withdrawn, then there is no opportunity for counsel
Do we assume that the jury isn't competent to give the verdict without the answers?
You have to. I mean, this is the core of what Obama says.
Or do you assume what the dissent says, that we must assume that they gave up the question?
You can't assume that. This Court in Hall said the jury is entitled to the guidance of the court and may not be relegated to its own unfettered course of proceeding.
So they have to answer the question.
I see this as it probably was error not to respond. The question is, did you have to object to it? And that that's really the core here, is because, and that's where we get into the gamesmanship and the strategy of it. And a good defense lawyer would say, well, if I don't object here and I got a mode of proceedings there in my pocket to get another trial, so that's the point. So is it correctable? Notice of content has to be a mode of proceeding there, because how can somebody object if they don't even know, right? That's very easy for all of us to make that leap. But the second part of the ORAMA standard, which is an opportunity to provide input, that second part of it, once you know what it says, you can either provide input or not. That's up to you. And if you're not given that opportunity and there's going to be a verdict and you don't object, then you're stuck with the verdict. You don't get two verdicts.
The problem with that, Judge Fahey, is that it gets the ORAMA analysis and the spirit of ORAMA exactly backwards.
So, counsel, I just need to ask, you said an explicit waiver of the answer to the question by the jury. So when the jury sent out the note saying we have a verdict, it would be your position, and correct me if I'm wrong, that the jury would have to say, ignore those other notes we sent out. We don't need that information. We have a verdict.
Correct. And they said that in this case. They withdrew an earlier question. But I need to get
back.
What, I'm sorry?
They withdrew an earlier question in their deliberations in this case. So clearly the jury knew how and could have done that. But
Go back to Judge
But that was
Pinckett's
during the
point.
course of deliberations, right? That's not, I've got a verdict. You don't necessarily at that point expect the jury to say, well, I don't need those notes, I've got a verdict.
if they don't, then the court has to confirm it.
To go back to Judge Pickett's point, I think it would be malpractice for a defense lawyer if he doesn't have an opportunity to respond to a note to ever object then, because he's always going to have a mode of proceedings.
But it can't be malpractice because the law will be clear that judges have to do this. The law is already clear. And I do need to make the point about why this is so important, because it makes no sense under ORAMA or under the mode of proceedings doctrine to elevate notice and make it more important than an answer to the jury. Let's think about the whole point of notice to counsel is so that counsel can give input to the judge on how to respond to the jury.
So to be clear, you're arguing there is never the possibility of implied waiver by the jury, implied withdrawal by the jury?
There cannot be, because if there is, then the whole point of ORAMA gets undercut.
But under your proposal, counsel, if defense counsel, and defense counsel obviously did have an opportunity to give input in this case, if defense counsel had said, Judge, I don't want you to answer those other questions, then your position would be the judge should ignore that input and answer the questions anyway.
Yes, and here's why. I'm quoting from Malloy. From 1982, this Court said, CPL 310.30, leave to the trial court no discretion whatever as to whether or not to answer a proper question from the jury.
Well, that may be true, but that doesn't answer the question as to whether defense counsel has to bring that to the attention of the judge at a time when the error can be corrected.
But it's already to the attention of the judge. The jury has issued a verdict as they're discussing three pending questions.
Well, obviously, the judge knows the situation. What I'm saying is that the error has to be brought to his attention. Judge, you know, you have to do this. That's what the law requires. That's why we require preservation.
The people say that there is case law supporting this position. There is none. The cases that they cite as saying that preservation and all of the cases where they say the court requires preservation, an answer was given to the jury's question. And that's fundamentally different, because what the case law that the people cite says is if the court answers a jury question, of course defense counsel has to put on the record yes or no whether he approves it or not. But here there was no answer given. This is fundamental. It is a quintessential ORAMA error. And it does require a new trial, and this Court should affirm the Fourth Department.
Hey, counsel, thank you. Counsel Rebuttal.
If I could pick up on Judge Abdus-Salam's sort of hypothetical, we could take that even a step further. You could have a situation where the people say, don't take the verdict. We think they need to hear those answers to those previous questions. And the defense says, no. Don't want them to. We think they've settled on acquittal. Take the verdict.
Do the people have any obligation to bring it to the court's attention that the court's required to answer the question?
No, and I guess I also don't think that the Court is necessarily required to answer the question. I think that the question here is, ultimately, was the jury withdrawing their previous request?
Is it the responsibility of the judge, though? Putting aside what the defense lawyer does, what the prosecutor does, doesn't the judge, under our precedents, have to answer the questions?
I think not if the jury has.
It's his responsibility, or her responsibility.
Not if the jury has sent out a note saying we've reached a verdict. I think it's
you're inferring that the jury has withdrawn their questions.
Right. And if the defense wants to question that, they certainly can.
No, but at the core of your argument is they come in with a verdict, we can presume that they don't want the answers to the questions, even though Orama says judge has to answer the questions.
Right. I mean,
our jurisprudence says judge must answer the questions.
Well, but it certainly doesn't say you have to answer a question they withdraw.
I didn't think you were arguing that the judge was right here, only that if the judge was wrong, you've got to object.
Right. I mean, I guess
there's a big difference between arguing they're right, because it's clear the Obama rules set out there an opportunity to respond, and there should be some response, and the better practice would be exactly what Judge Lippman says. But the question is, do you have to preserve an objection to it, or is it a mode of proceedings error which automatically entitles you to another trial?
Right. And I'm not particularly trying to insist that there wasn't an error here. I think we don't really know, because nobody asked the jury, by sending out a note saying we've reached a verdict,
do we not create more confusion, though, with respect to the Orama protocols by doing exactly what you're suggesting, which is every other note, yes, a judge has to respond to it, but if the notes are pending and a verdict comes in, judge doesn't respond and the defense counsel doesn't object, no mode of proceedings. Every other case is mode of proceedings, but not that one.
No, the rule is clear now. It becomes confusing if you accept the defendant's position, because the statute says meaningful response.
Aren't we making it up as we go along by saying, in this situation, they withdrew the question? It's fundamental that the judge has to answer the questions. And now we're saying, yeah, it's fundamental, but we can infer that they don't want the answers to the questions.
I'm not saying anything different from what was in Orama, that Orama creates a motive.
No matter how long the notes have been pending?
I think that matters in terms of what the appropriate response is if there's an objection. I don't think it matters as far as whether or not there's a mode of proceedings there. Again, given that the counsel has noticed.
I'm not sure I understand your answer. If the notes had come out, if one note had come out, 2 minutes had passed, and then the verdict comes out, is that different from the almost 2 hours and 3 notes are pending? I think it's
I think it changes how the judge has to respond to an objection. If the defense says, Judge, I object, it's been 8 hours since you said you were going to do that readback and there hasn't been a readback, I think,
No, I'm sorry.
No, I'm taking a ridiculous example.
My question is, does that differ your analysis or impact your analysis on whether or not there's an implied waiver? Whether it's 5 minutes, 2 hours, 5 hours, 8 hours in your hypothetical.
I suppose that's relevant, again, to the question of whether there's an implied waiver. But
so then again, aren't we creating more confusion? Because you sound like you've got a little sliding scale argument going on there. Are we creating more confusion, allowing then courts to have these arguments? Well, it was 5 minutes. Oh, no, it was 5 hours. Oh, no, it was 94 minutes, whatever he said.
No, because by making it not a mode of proceedings error, that gets fleshed out in the trial court.
You're saying even if it's not a case where, as here, the jury comes back with a verdict, you're saying any time a judge doesn't answer a note and the lawyers know about the note, they know the contents of the note, and the lawyer doesn't say, hey, judge, you got to answer this note. You're saying that is not a mode of proceedings error. The lawyer has to make the
Right. If, as Orama says, if they have noticed.
But I return to the question I asked you before. Isn't it the responsibility of the judge? Isn't that what this is all about?
Sure. And it's the responsibility of the judge to do other things in the Orama procedure that this Court has found are not.
It's a fundamental core responsibility of the judge to answer the questions. That's what Orama is all about.
Yeah, but I mean, if the jury.
If the answer is yeah, then how can you prevail?
Because the jury is sending out a note that says we've reached a verdict. So it's reasonable to infer.
I think what we get down to, Judge Fahey said it a little differently, is I get that, they knew the note, but can't you get on the record from the defendant or defense counsel what he wants to do with the notes? If he says, I don't want them read, then let's argue that out. In building a conspiracy or a weird thought, I mean, within these notes, they wanted reasonable doubt explained to them again. Somebody also wanted a smoke break. Now you're 2 hours down the line. That poor bastard hasn't had a cigarette in 2 hours, and he's the one that asked about reasonable doubt, and he's not about to spend another 15 minutes waiting, so he says, all right, fine, throw it in. And he never gets the instruction on reasonable doubt because he never got the smoke because the judge never read the notes. I mean, shouldn't
we have no idea about it.
Should we guard against that and not simply say, well, it wasn't preserved?
No, because if the defense attorney has notice of it, he can raise that issue if he's concerned about that. But if he's looking at this case and saying, I think I got an acquittal, I don't want you to mess with the jury.
Shouldn't he say that?
Well, we don't know what he said. I mean, it was
the more likely thing would be, I think I'm going to be convicted, which is probably the more likely thing. And so what he's really going to say is, since I think I'm going to be convicted, I'm going to take the verdict. If it goes my way, great. If not, I have a motor proceedings error and I get a new trial. That's what you're saying. So object, so the judge can correct the error and we won't have that motor proceedings error.
So the ADA can stand up and say, Judge, you know what he's trying to do? And then he or she can say, you got to read the notes, Judge, and find out what they're about, because otherwise you're handing him a motor proceedings error.
Yeah, I mean, but all of these things are going to be better if we require an objection where the defense is in a perfect opportunity to object.
But the judge is responsible, and it's Friday night, and like Judge Piggott said before, isn't there a danger as to what's going on here that by the judge not doing what the judge is supposed to do proactively, and that's the basis of what he or she is supposed to be doing under arrest?
And so maybe it's an error, but it's not a motor proceedings error.
Well, you're both great. See ya.